Okay, I think we'll get going because it is 9 o'clock now. Welcome everybody to this CPD on children in criminal law. My name is Lauren White, though I'm showing up as Lynn Pagage because I'm using this is Lynn in the background. I'm using her computer at the Law Society office. I'm a member of the Law Society's CPD committee, so I helped organize this event. So today I'm going to be moderating our three speakers. We have Simon Renouf in the top left-hand corner there. Thanks, Simon. We have Noel Sinclair in the bottom left corner with the penguin tie. And we have Kelly Manweiler in the bottom right corner. So Simon Renouf is a defense counsel from Alberta. I'm going to be doing more fulsome bios when I actually introduce each speaker. But just so you know who you're going to be listening to, Simon Renouf, as I said, is a defense counsel from Alberta. Noel Sinclair is general counsel with the Public Prosecution Service of Canada. And Corporal Manweiler is corporal with the RCMP and M Division, which is Whitehorse, Yukon. So how it's going to work today, we have 3 hours, which is a long time, obviously, to be staring at a computer screen. So how we've divvied up the schedule is Corporal Manweiler will be speaking for half an hour right away on best practices in interviewing children. And then we're going to take a 15-minute health break. So, you can go off and do whatever you need to do during that time. So that will take us to 9:45. And then at 9:45, Noel is going to give a Crown Counsel's perspective on interacting with children in criminal law. That will take us for a full hour to 10:45. We'll have another 15-minute health break. And then Simon will finish us off at between 11 and 12 with the defense counsel's perspective. How we're going to be managing questions is all our speakers have said that they're comfortable being interrupted while they're speaking if you have a question. So if you have a burning question you want to ask, just take yourself off mute and go ahead and ask your question. If you're not comfortable doing that or you're a little shy, go ahead and write your question via the chat function, and I'll be keeping track of those as we go on. And then at the end, depending on how many questions we have, we'll leave maybe 5-10 minutes for the panelists to answer those questions. And just so everyone is aware as well, we are currently being recorded, and this CPD will be posted to the Law Society website. So if you do have to run out for court or whatever else partway through this, don't worry, you can always access it later through the Law Society website. So with that, a big thank you, and I'll say this again at the end, obviously, but a big thank you to our panelists for agreeing to be here and speak to us today. So today we're going to start with Kelly Manweiler. So Corporal Manweiler has a Bachelor of Arts degree from the University of Winnipeg with a double major in Justice and Law Enforcement and Conflict Resolution Studies. She's been an RCMP officer for 21 years, so obviously very experienced. Through her service, she's been passionate about working with survivors of sexualized assaults, domestic violence, and child abuse. She was fortunate enough to take her first training in interviewing children in 2001 and has been mentoring other members in child interviewing throughout her service. She also is a stepwise child interview trained, and she's a stepwise instructor. So I'm also hoping as she speaks, she can explain to us a bit about what that means. So Corporal Manweiler, take it away.
Thank you. I'm just going to apologize in advance. I have 3 dogs. 2 of them are very small, and anything that moves outside my house attracts their attention. So if you hear a beagle and pug going wild, I apologize for that. So the RCMP does use, we're currently using the late Dr. John Yule's stepwise interviewing method while we're interviewing children. Obviously, children are an invaluable resource. They are more perceptive than what we think, witnessing events occurring in their own home between parents, siblings, or being victimized themselves. Not only do we speak to children to determine what occurred, we also want to speak to them to assess possible trauma, safety, and risk. The issues we have are how to get the information from children in a manner that can best be understood by adults. And so, with stepwise, it's like a phased interview approach. We want to ideally minimize the impact on the child maximize their recall while minimizing contamination, and maintain the integrity of the investigative process. So in that, we often consider where we're going to interview a child. We want to use a room designed for children, quiet and free from distractions, no wheeled furniture, toys, or phones. We'll often use, we'll go into their schools often. And we always tell the children that they are being recorded. We will show them where the audio and video equipment is. And we don't want to interview the child where the abuse has occurred. We want to schedule our interviews around the best time for the child. So often we'll speak to the parents and the teachers to see when they're most alert, when they've eaten, when they have nap time, medication times, and take that all into consideration. So recognizing that we want to make sure that when we're sitting down with them and speaking with them, that it's going to be the best possible time for them. And also recognizing that the younger the child, the shorter the attention span we have. We want to make sure that we use the child's name during the interview. We don't keep them waiting. That if we do have to keep them waiting, that we do have a waiting area for them, that we can keep them occupied. And we want to get physically down to the child's level when first meeting them. We don't want to be over top of them and just being this big scary figure to them. So I will get down to their level, I'll crouch down, and in the interview room, I'll sit on the floor most often with them. So, during the interview, where possible, the less people in the room is better. We'll run sometimes into conflicts where a parent, a guardian, or support person wants to be in the room. We'll try to work our way around that, but in some cases, they have to be in the room. So then we'll consider where we're going to place them in the room. We want to make sure that everyone's seen on video, but that the child's not looking to their parent or their support person for all the answers, and we don't want that person answering for the child. We also often work with Family and Children's Services, so we will do joint investigations. Usually we'll try to plan ahead as to if there's going to be two of us in the room, what that's going to look like. Or if we'll have the social worker or the police officer sitting in the monitor room, just so that we're not overwhelming the child and bombarding them with questions. We also want to make sure that we are covering off Family and Children's Services mandate with the protection issues as well. And so, we always want the interview to be video recorded, and we will use an audio as backup. We'll treat the interview as an exhibit. If there's a if there's a disclosure, we know that the possibility is that it could be tendered into court as evidence, and we want that best evidence available for court. We don't want to put the change the child's words into our own. We don't want to use closed or forced choice questions. We don't want to interrupt. We don't want to change the topics rapidly. We want to minimize distractions. We have to be very careful with physical contact with the child. And we want to be open-minded. So, we want to use non-suggestive positive reinforcement once a child's speaking, nodding our head, just use their words. If they become upset, then validate their emotions again, and be honest. Children will often ask you what's going to happen, so you have to be honest with them because they're going to read right through you. So let them know what's going to happen. With the stepwise method, we go through phases: the preparation step, the intro, building rapport, establishing the need to tell the truth, introducing the topic, the narrative step, enhancement step, review step, and conclusion. I'll try to go through each of them here quickly for you. Our model is prepare twice, interview once. That always doesn't work, but that's kind of our goal. So we want to interview the parents or the guardian beforehand, so that we have an understanding of their child's language, their understanding of body parts, words they use for those body parts, nicknames for anyone that they may be disclosing to, understanding of right and wrong, types of punishment used in the home, and how did the parent learn about the abuse or the allegation. For non-offending parents, we want to get that parent on side and gather as much information we can about these folks and what occurred, and then assess their response into, do they believe the child, and what is their abilities to protect the child going forward. We'll always tell the parents that we'll meet with them afterwards to discuss what their child had to say. We'll ask them about special events in their life to help with timelines like birthdays, if they just had a special outing somewhere. And then we'll discuss with them the disclosure and see, like, if we're missing something or didn't understand something in the interview, maybe the parents can provide a context to that. The first disclosure person, we want to interview them first. Often it's going to be a parent or a teacher at the school, social worker, counselor. So we want to know how that disclosure came about, what all was said, the context of it, and then keeping in mind that we often put our own spin on things. So just keep that in mind, that what was said possibly wasn't what the child was meaning or how we need to interpret it as. So don't assume you know what happened going into the interview. You want to consider possible motivations for the disclosure. So you want to look at the context of the original disclosure. Was the disclosure initiated by a parent of the child? Is this a custody dispute? Is there other motivations, revenge? Is there pressure to disclose, where the child is denied abuse repeatedly but keeps being asked, so they finally just make something up so that they'll stop being asked? So you have to keep all of that in mind. We want to be aware of our own reactions during the interview, remain calm and relaxed. Children are perceptive. They'll look to see what your reaction is as you're talking to them. So you don't want to appear shocked with anything. We also want to be aware of their needs. If they need a break, if they're starting to do the potty dance, if they're getting hungry, just be aware of all that stuff and address it as it comes up. We realize that children don't necessarily understand when, so we won't ask when questions because they don't have an understanding of necessarily of time for the younger the children are. So we want to develop their timeline based on time of year, seasons, birthdays, special events, holidays, TV shows, bedtime, school time, bath time, eating time, that sort of thing. And recognize as well with counting, they can't tell you necessarily how many times something happens. You can ask them if it happened more than once, the first time, the last time, a time that it happened differently, because they're not going to recall, like, yeah, this happened 17 times. They're not going to remember that. And recognize as well that certain words that we use, like any versus some. If you ask it, does anyone know about this? It'll often be no. Does someone know about this? Then you'll more often get a response of yes. You don't want to necessarily give the child the option of telling you if something happened or not. So don't ask them, can you tell me? We want to make sure that we just say, tell me about this. So, and why questions we try to avoid as well. It's seen as negative for the child or accusatory. So we don't want to ask, why didn't you tell someone? Because you're blaming them. Instead, you want to ask, did you tell someone? So, you want to recognize as well that children mix up he and she all the time. So where you can, just use people's names. And if they are using he and she, just clarify, because kids often mix up he, she together. So sometimes we'll ask if it hurts. You have to be very careful using that word as well. because they relate to pain when often molesters are careful. They won't actually cause pain often, so they might not associate what occurred to them as being something that hurt. So yeah, pay attention to the child's language, use words that they use. If you're unsure about the words that they're using, then clarify. Often children will say like, how many floors did your house have? When they really mean how many levels, was it a 2-story, 3-story, was there a basement, whatever, but the children, they know like, okay, the floor is what I walk on, so yeah, it had 3 floors. So keep your language simple and age appropriate, speak slowly, and allow time for the child to process information. Stop at regular intervals and ask them if they understand. Now, I'll often ask the child too, saying, hey, just sometimes I'm not quite sure, I don't quite understand what you're saying. So if you don't understand me, let me know and I'll rephrase my question. I'll ask it in a different way so that we both know what we're talking about here. So, and only ask questions that are purposeful and necessary, because you do that would be the beagle, sorry. And we want to be mindful too with cognitive issues. So sometimes you'll need to provide extra time during the rapport stage for children who are a little bit slower. We want to ask short questions with simple vocabulary and keep things slow. If there's multiple incidents, we only want to focus on one at a time, and we'll label each incident. In our introduction phase, we're introducing ourselves and we're assessing the child's ability to respond to questions, the level that they're at. We can ask them to know what today's date is, how to tell time. I'll ask them colors, just to kind of see the level that they're at and kind of the types of questions that I may be able to ask them. And I'll also explain that I am a police officer, and a part of our job is to talk to kids, to keep them safe, to see what's going on in their lives, just to make sure that they understand that they are speaking to a police officer. So we want to put the child at ease, and sometimes this does require more than one meeting. Our secondary goal is to ensure that we want to encourage the child to talk.
Sorry, Kelly, to interrupt. We're having trouble hearing you.
Sorry.
No, it's okay. Do you want to take a break?
Give me 2 seconds here and I'll go see it.
I was just concerned about the coyote at the back door.
Okay, hopefully.
Great, thanks, Kelly.
It's upstairs on a bed, looks out the window and barks.
Always better with a dog.
Yeah. So we want to, when we're building rapport, we're seeing the child's ability to answer our questions, looking at their memory as well, seeing if they can recall events, getting them kind of in the habit of answering our questions like, okay, so you told me like soccer, tell me more about that, so that we can see their ability to recall events. We'll also look at establishing their use of understanding of concepts like over, under, inside out, assessing their ability just to relate things back to us. And then often we'll use our own personal experiences to relate to the child, so that we have a way to connect and that they feel comfortable with us to allow for a disclosure to happen if something occurred. In our report phase, do we want to get into the habit of them expanding on answers, not just answering yes and no? Usually we'll spend about 5 minutes. in this phase, because again, we only have a limited amount of time, just based on the child's attention span. And so. We'll use this phase as well as if they're saying that they don't remember, and we'll just relate the, hey, that's fine. That tells me that you're not guessing, that you're not sure about something. That's completely fine. And that, yeah, as we're going through things, if you don't understand or if you don't remember, that's okay. Just tell me that and we'll move on. So, and we want to make sure too that often they'll have already disclosed to a parent and they know that we've spoken to their parents. So that we'll just have learned the information from their parent, but we want to make sure that we tell them that, hey, look, if you think I know something, just tell me anyways, to make sure that I do know. We won't get mad or upset with them, and we only want them to talk about things that are true or things that really happen. So. Again, the child's age and their condition will determine how long the interview can last. They may get bored if we spend too long in the rapport building phase. So we got to be cognizant as we're talking with them. They're going to drive how long the interview is going to go, and you're going to know pretty quickly, hey, I've got a limited time. Their attention span's really short here, so we got to move through things pretty quick. Sometimes we'll use gingerbread drawings in this phase, so we get an understanding of their terminology for their body parts, and we'll label all the parts, not just the sexual organs. So I'll start at the top with their hair and work my way down through, and then we'll put those aside for later on if necessary during the interview. But just kind of allows you as well, allows you to kind of get them focused if they're starting to wander a little bit, brings them back to you, and you've got that covered off for later on if you need to. So we will cover off the need to tell the truth, even though it's not necessarily a requirement. We do still try to cover it off. Crown likes it, and I think the courts like it as well. And it helps kind of us assess it. They have to be able to understand and respond to questions, and we want to have an understanding of if they do know the difference between the truth and lie. We want to make sure that what they are telling us is the truth and something that actually happened. Even if they don't have a clear example, keep going on with the interview. Children are not likely to be sophisticated liars. So if it's missed early on in the interview, just cover it off in the end. I'll go back and I'll say, hey, so you told me about this and this, did that really happen? Or just to make sure that it's covered off and that there'll be no issues court time wise. Getting on topic is kind of sometimes the hardest thing. We need to find out what happened to children, and if nothing happened, we need to make sure the child didn't say something did occur. And so we want to we do like a funnel approach where we start super broad. We'll ask them about who else in their family, things they like to do with that person, things they don't like to do about, things they don't like about that person, people they like, people they don't like, their best experiences, their worst experiences. Often we'll get disclosures there. If it's their dad or their brother, I'll go through each member of the family, but I'll say, okay, tell me something that you like about your mom. And I'll say, whatever. Tell me something that you don't like about your mom. We'll say, whatever. And then tell me something that you like about your dad. Sometimes they'll struggle with that if their father's person who abused them. Often I'll get a disclosure if I ask about something that they don't like about their dad. Often you'll get disclosures there. So, or yeah, best experience, worst experiences as well. So yeah, we want to start broad, and then if there's a disclosure there, focusing on that, and then move back out again as well. So secrets, We will ask as well about sometimes if we're not getting anywhere. So we'll discuss secrets, good secrets and bad secrets, secrets that we can keep and secrets that we need to tell. That's where we can use the body part pictures as well for younger children. And then often I'll have them help me draw a bathing suit on the gingerbread person. And if I'm not getting disclosure and we need to know, they'll be, has anyone ever touched you in the parts that are covered by your bathing suit? So has something's happened? Okay, tell me about that. And we'll back out and we'll focus back in again with the questions. So at the end of the day, if you're not getting the disclosure and you believe something occurred, sometimes you just have to come out and ask, hey, I know you told mommy this. Tell me about that. If you're still getting nothing, then you might just have to call and say, hey, okay, so you told mommy this, daddy touched you here. Did that happen? And then hopefully you can get an answer in regards to that and focusing on that.
Kelly, sorry to interrupt. We've got about 4 minutes to go and we've already got a question. So I'm wondering if this would be a good time to start answering any questions the participants have.
Sure.
So if anyone does have a question, feel free to shout it out, I guess, though apparently I have to give you permission to talk or put it in the chat function. But our first question was whether children are always interviewed alone or under what circumstances can a parent/guardian be present?
Yeah, so sometimes the child won't talk to you at all without mom or dad present. I've had grandmas in the room as well, where I give them a heads up ahead of time to the parents, and I'll tell this to the child while we're in the room. Okay, I have a job. My job is to keep you safe here today. Your job is to answer my questions, and mom or grandma's job is to just sit here and be with you. If they can't answer questions for you, their job is to be quiet and just be here for you. So if at the end of the day, if that's the only way that you're going to keep the child in the room with you to discuss what happened, you have to do it. So, yeah.
Okay. And I had a question actually for defense counsel or for Crown for that matter. When you're watching an interview of a child, what should you look for in terms of, I guess, mistakes that the interviewer might have made that could cause litigation risk in your case? Well, I guess for defense counsel, you're looking for mistakes that you can bring out at trial, but what kind of red flags should we be on the lookout for?
I think leading questions are going to be huge. Yeah, leading questions I think would be a big one. And then just maybe not being able to see, if we're sitting on the floor and I'm doing diagrams, maybe not being able to see the child's writing versus my writing. Maybe not understanding some of the words that are being used in the room, and then with the interviewer, maybe putting that into their own terminology, not using the child's term, or not making sure it's clear for the video that this is a child's term. So from now on, the vagina is now called the frog. So just making sure that that terminology is clear. Yeah, it's kind of a hard question.
Sorry. And so we have another question from a participant. If the child is being fed information or is disclosing because they are being asked so often that they make something up, is that obvious in the interview?
Yeah, they can't keep their story straight. So if you try to have them explain things, try to have them explain it again, they can't relay the same information. So, or they can't provide a context to that disclosure. And those are rare as well, right? Like we're not seeing, you'll know pretty quick whether or not the child's telling you the truth or not. Their body language is huge. I've seen it before where they've looked up at the camera and smiled because they know their parents in the monitor room. Yeah, they can't quite provide a context to the information that they've been told to say in there. So you learn pretty quick and you just get a bad feeling. So when you go back and ask more questions, they can't answer those questions for you because they haven't been coached on that.
Kelly, I wanted to ask you about the interview protocols around unrecorded conversations, like before the child comes into the room where the videotape is located, and after the child and the parent leave the room where the video recording is going on. Are there policies or procedures that that cover those periods of time?
Yeah, so we're encouraging the members to make sure they have their audio recorder going and have it on them. So when they're going to the front of the detachment, meeting the child and bringing them down to the interview room, to make sure that they have their audio recorder with them. And then again, when they're walking them out as well, just in case there's further disclosure made. I don't know necessarily if it's written into policy, but we're trying to relay that in the latest courses and stuff that we've had, just so that everything's covered, right? Like just like you would in a warned interview, to start that recording the second they come into the office until they're out the door, to make sure that we have everything covered off.
And I take it that the investigators are trained to not initiate any specific conversations other than, good morning or how are you today, before you get into the recording environment?
For sure. Yeah. So often when we're walking down through to the interview room, because, well, they moved our interview rooms a number of years ago, but I'll point out, like, we have a bison head hanging up in the hallway there. So I'll point out that and just yeah, are you like, and I'll ask them if they've had something to eat this morning or what they did before they got there. So nothing about the actual interview itself, but just trying to make them feel comfortable as we're going down to the interview room.
Great. Okay, I think we're out of time. Thank you very much, Kelly. That was very interesting. So we're going to take, well, now it's more like 13 minutes. So we'll come back at 9:45 and Noel will be speaking next. Thanks. Okay, welcome back, everyone. So our next speaker is Noel Sinclair. Noel is a retired Northwest Territories fishing guide who graduated from Dalhousie Law School in 1993. For the first 9 years of his legal career, he worked in private practice in Yellowknife and on Vancouver Island. He joined the Federal Prosecution Service, now PPSC, as Crown Counsel in 2002 and has since focused on criminal prosecutions across the northern region. He currently serves as General Counsel for PPSC in the Yukon Regional Office and is active as a trial and appellant lawyer at all levels of court in the Yukon. He's a past member of the Sexual Assault Response Committee and played an active role in the development of the LINKS program for supporting child victims and witnesses. And he's going to be speaking about practical tips for lawyer in terms of pre-preparation for trials, as well as legal principles regarding the treatment of children's evidence in criminal trials. So welcome, Noel.
Thank you, Lauren. I hope everybody can hear me clearly. I will repeat what Lauren mentioned at the beginning, which is that I'm happy to respond to questions or interruptions, whatever, during the process. So please speak up or chat or however you are able to communicate. I see at the bottom of my screen there's a Q&A button and a chat button. I suppose if you have questions, they should probably be posted in the Q&A button, using the Q&A button. So my topic this morning is to, as Lauren said, to discuss developing rapport with child witnesses, pretrial preparation for trials involving children, and to talk about some of the legal principles concerning the treatment of children's evidence. From my perspective, the first two topics, developing rapport with child witnesses and pretrial preparation, can be kind of merged into one continuous dialogue, I guess I will call it, and that's how I'm going to treat it. And then I'll speak last about some of the legal principles. Before I get too deeply into the material, I want to tell all of you who may not know about it, about Project LINKS, which is a multi-stakeholder initiative that began back in, I think, 2015 and launched, I think, in 2016. It's mainly an initiative of the government of Yukon and is run out of the Victim Services branch. And it's a service dedicated to providing information and supports to children and parents where children are involved as witnesses in court proceedings. And I don't know how much of Lynx's work is related to civil lawsuits, but certainly they provide excellent support services, comprehensive support services to families and children who are involved as witnesses in the criminal law proceeding. And I would be surprised to hear that they, were limiting the scope of their services in civil law. And one of the things that is available from Lynx is this booklet. Let me see if I can show it to you. A resource guide for justice professionals working with child witnesses in Northern Canada. And it's I don't know how many pages it is, a 40-page, very helpful booklet of information concerning working with children victims, and some of the material that I'm describing is covered in this booklet. I would recommend it highly. My only complaint with the booklet is that on page 4, there's a picture of me reaching out, apparently lunging at this child to strangle her in one of the witness rooms at the courthouse. I will say that is Lindsay Roberts' daughter, a paid model for this, and all the other kids. These aren't real photographs. Lindsay Roberts is the director of the program and has developed extensive expertise in assisting families. And there's also healthcare related stakeholders involved in this. There's victim services, all kinds of Crown supports and information and that kind of thing. So I would, if you work with children in the administration of justice, I would highly recommend that you obtain a copy of this resource guide, which has a large volume of excellent information. So in terms of developing rapport and pretrial preparation for trials involving children, we need to remember that, a child can be anything from a toddler to an adolescent to a young adult, and that there are obviously different kind of developmental milestones for each of those different categories of child witnesses. And we need to be mindful of those. I think that sometimes as lawyers, perhaps some of us, including myself, develop these habits of presentation. We deal mainly with adults, and maybe we tend to follow some of those routines that we've developed for communicating with adults when we encounter children. Our patter in terms of trial prep needs to be modified very significantly with a specific understanding of the different developmental capacities of the witness, whether they're very young or a young adult. We know that children develop language and abstract reasoning capabilities throughout their growth, and depending on what stage the child is in, there are going to be, organic limits to their ability to express themselves or their ability to understand abstract concepts, and you can't sort of put a specific age on the availability of abstract reasoning for a child. All of them are different, and you're going to need to gauge that well before you start interacting with the child. There are also memory capabilities that develop throughout our lives, and I suppose decline later in life. and we need to be mindful of those, and judges as well need to be mindful of how children's memories work. And I'll come back and speak to that in a few minutes. And as well, children, will have difficulty recounting details for a variety of reasons. As well, children's perception of time is very much different from an adult's perception of time and the ability to express concepts of time, and that's something that we need to be careful around. The first thing that I recommend is for the lawyers is to build a team around you. I've talked about some of the resources that are available for Lynx, from Lynx. There are victim services supports. There are medical supports, perhaps, that you can work in conjunction with. And before you even think about meeting with the child, I would recommend that you gather information, background information concerning the child from the team that you've built, your victim support workers, the Lynx program, doctors, psychologists, the parents. Find out things like, what is the child's preferred name? Is it John or Jonathan? Is it Becca or Rebecca or whatever, so that when you get to that meeting with the child, you don't start out by putting your foot in your mouth. You want to be aware before the meeting of special needs concerns for that child, so that you can adapt your meeting and your interview of the child to address those special needs or concerns. You want to understand their relationship with the accused person in the criminal context, or the family composition and the family dynamics in a civil context, so that you aren't necessarily having to spend a lot of time asking the child about all of those things, because your time with the child in an interview context is precious, in the sense that sometimes you're going to run out of time quicker than you think, and you don't have unlimited time, although I agree with Kelly that you do need to take your time with children as well. But to the extent that you can gather information about their living arrangements, or cultural awareness about the child, language competencies of the child, where the child goes to school, who the child's friends are, what are the child's interests, get that information at the front end, so that you don't need to necessarily spend a lot of time with the child developing that information. You need to anticipate that almost every child witness is going to come to a meeting with a lawyer feeling reluctance, anxiety, confusion, and fear. I had thought when I started working as a Crown Counsel that it was going to be easy, because we would have all the police helping us and these witnesses would want to come and get justice. But we certainly do have the help of the police, but there are very, very few witnesses who I've met with who were excited to come and talk to the lawyer and, get prepared to come to court. We need to avoid formality in our presentations with the children. Kelly talked about being in a room that is comforting, or the soft room is what we call it in the context of RCMP interviews. We need to be aware of the location that we're choosing to meet the child. It doesn't necessarily, and perhaps shouldn't be, in a lawyer's office sitting across a desk from a lawyer. We need to be aware of the clothing that we're wearing. So if I'm meeting with a child, I might take off my tie, for example, take off my jacket, come to court wearing more casual clothing, so that there isn't that apparent kind of barrier or difference with the child, that they're not frightened of you as a person in authority. And we need to be very careful about the way that we express ourselves, the language that we use, and the sophistication of the language. And again, that takes me back to this kind of lawyerly patter that we've developed to talk to adult witnesses, and we really need to concentrate, I think, and be aware of trying to avoid that kind of learned presentation. I also made a note here about avoiding phoniness. I think from my own experience as a child that children are extremely adept at recognizing phony presentations to themselves, and that they will tend to shut down if they feel that you are being overly cute or speaking in a high-pitched voice or being too excited or overjoyed about some, insignificant piece of information that the child provides you. And my own style is to be much more, matter of fact or calm. And I suppose it's up to everyone to choose how they want to relate to children. But again, that's something that I remember from my own childhood. That there were certain people that I met that were just a little bit too exuberant, and I don't think that helps. Although it seems to be the way that we see some people relating to children as a way of kind of they think making them feel comfortable. I won't belabor it. You need to plan your conversation with the child before the interview starts. You need to identify the topics that you want to discuss. You need to consider whether or not it's important for the child to review any pre-existing recorded or written statement that the child has provided about an event. And in my own practice, typically I try to get a sense, without going into the details, of whether the child actually remembers what it is that they need to go to court to discuss. And if it's pretty clear that they're mature enough and they understand that, I personally tend to stay away from talking about what their evidence is going to be, and I don't require the child to recount things specifically about traumatic events. But that's a call that is made on a case-by-case basis. Sometimes you do want to spend some time reviewing a statement with a child or an adolescent or a young adult witness, but it's something to think about. The meeting doesn't have to be about going over their evidence. It can be more about describing what's going to happen without getting into the specifics of them answering questions. I tell witnesses that I'm going to start out with some easy questions, and then I'm going to take them to the part of the evidence that's important, and I'm going to say to them that, did something happen to you on such and such a day? And I tell the witness, I just want you to just talk and give a kind of a pure version of what happened. And tell them that's the time for them to flush it out, and then I will come back to them and ask follow-up questions if they have left out information. And that the quickest way for the witness to get out of the hot seat in the courtroom is to provide that information. So if they're nervous, recognize that by blurting everything out when they're given the opportunity is the way that they're going to be able to minimize the amount of time. Another good technique, Kelly talked about a bunch of techniques in terms of asking children how or what happened or how things happened. Another question that I might ask a witness in testimony more so than in preparation, but it might come up in testimony, is what is your clearest memory of what happened to you? I think as lawyers, we tend to approach evidence or the giving of evidence kind of chronologically or sequentially, and that's not how the neurobiology of trauma works. Certain events, certain parts of events are imprinted very vividly, and then the peripheral details around those events are much more vague or unremembered, and respecting that and giving a witness an opportunity to describe their clearest memories is perhaps a more effective approach to gathering the evidence than it would be to say, okay, let's start on January 1st, and you tell me a sequential chronological story from that. I think that can be confusing and frustrating for witnesses. So, what's your clearest memory? Tell me everything that you remember about an event, that kind of thing, and then you're telling the witness, that this is how you might be approaching the questions in court. I talk to witnesses about, don't guess with your answers. If you don't know, say you don't know. That's okay. If you don't remember, that's okay. And throughout the interview, I find opportunities to reiterate to the witness, if they don't remember something, that's fine. Our main focus is to tell, I want you to tell the truth. And there's nothing better than being in court, and when the witness gets under cross-examination and the opposing lawyer says, well, what did you meet with the Crown Counsel before this, and what did the Crown Counsel tell you about this, or that kind of thing, and the witness says the lawyer told me to tell the truth, and a little halo lights up over the Crown Counsel's head. It's wonderful, and it happens occasionally. I tell the witness about what to expect in cross-examination, and usually I'm able to tell the witness, almost invariably, I can tell the witness that the opposing counsel isn't going to be a bully, and that I tell them some information about the opposing counsel, and I say that it's not like television, and that the judge isn't going to put up with bullying behavior, and that the defense, it's not going to be like what you see on television. So again, tell the truth, and you'll get through this quickly. I also talk to the witnesses about anticipating the invariable "is it possible" type question, and I tell witnesses something along the lines of, listen, you know what you know, and you don't know what you don't know. It's okay to say I don't remember, but it's also okay to say that you're very clear that it isn't possible that something else might have happened to you if that's what your memory is of the thing, and let them know how to deal with those "is it possible" questions, then that's a likely strategy. I will often for these meetings, I will have it in an area where there are refreshments available for the child, that there are toys available for the child. I once worked in a law firm that had an area reserved for meetings with children that had, toys and paintings on the wall and that kind of thing. And again, that comes back to the formality. When you get to the meeting, you want to explain the purpose of the meeting to the child. Tell them, if you can, how long the meeting is going to take. Tell them about the topics that you're going to be discussing. Describe your role in the proceedings in very simple terms. I think many children and many adults as well don't really have a very clear idea about the legal process or about the specific roles of lawyers. You can also tell the children that you've worked with lots of children who have done this before, who have gone to court before, who have testified, and I think that is reassuring to children to let them know that that there are other kids who've done this and that they can do it, and try to build confidence for them. You need to take your time in the interview, and one of the key pieces of advice that I will offer to all of you is at these meetings, before you get into a long sort of description of anything, the first thing that you want to start with is letting the witness speak first. Ask the witness, how are you feeling about being here? And my perception is that people come into these meetings, adults and children, all wound up and all worried about some 1 or 2 or 3 things, and until they get a chance to get those feelings or those questions out and into discussion, they're not going to hear very much of what you're saying. They want to say something to you first. So that's one of the most important, I think, things about sitting down with any witness is to let them speak first, and then deal with those issues first. Be patient, be flexible, be alert to the child's level of stress. You know, you might need to take breaks, you might need to reschedule follow-up interviews, that kind of thing, depending on that. And you need to keep the meetings as short as possible. Kelly talked about the kinds of questions that they ask for investigative reasons to get information from children in a non-leading fashion, and that's forensically obviously very important. It's also important in terms of developing rapport with children, because lots of us know who have kids or are around kids a lot that there are a lot of kids that aren't really all that willing to volunteer information to adults. And the best way to draw children out, if you can, is to ask very open-ended questions. So, for example, you might say, can you tell me something about your favorite sport or your favorite book or your favorite activity, whatever. Tell me something about. Don't ask, do you like school, or do you like sports, or do you like reading, or do you like, certain activities? Because those kinds of questions are narrower, they funnel down, and children who are introverted or anxious or just uncomfortable will just give you a yes or a no answer. Whereas if you ask them a broader question that requires them in answering it to provide a little bit more information, you're going to start to draw that child out of the child's turtle shell. I think it's very difficult to learn that skill, and to some extent, I think about my own parenting relationship, and I'm kind of asking you guys to take my advice because I'm not using it. So these are skills that you really need to concentrate on and to develop within yourself to create that open environment. And Kelly talked about the ineffectiveness of the "can you tell me" prefaced question, and I agree 100% with her. And I had in my notes advice that has been hard learned by me, and it applies in the preparation context, and it really applies in the courtroom context. Never ask a witness, do you remember something, unless you want that witness to say, I don't remember. I think if there was some sort of an empirical study of this, you would find that prefacing a question, do you remember what happened next? Or do you remember who was in the room with you? Or do you remember anything? For some reason, it just primes the witness's pump to answer, I don't remember. Whereas if you simply ask, who was in the room with you at the time, you're not providing that off-ramp for them to answer that they don't remember. And I don't know. I mean, I can't tell you that there's any sort of scientific data on this, but the school of hard knocks and experience has shown me that do you remember questions usually result in I don't remember answers. And you will be surprised, how often people ask those kind of questions in court. So keep an eye on that as you go forward in your own litigation practice. You can use follow-up questions if you're getting blocked by a child, by a quiet child, an introverted child, a reluctant child, with these open questions like, tell me more about whatever it is that you're talking about. And obviously remember that you are preparing a witness to testify. You are not coaching a witness or, preparing for a scene in a movie where they have lines that they need to remember and you want them to follow the script. That's ethically impermissible and it's not good advocacy. So, with the work that we do, we're asking questions, and we all know about the 5 W's: who, what, where, when, why. Remember that younger children have difficulty with why questions. They also have difficulty with how questions, which require more abstract thinking. So to the extent that you can avoid those kinds of questions, particularly with younger witnesses, you will avoid confusing the witness. What if questions are also difficult for children at sort of lower levels of cognitive capacity, as are questions requiring children to estimate time and questions requiring children to estimate size. So you might not get good productive answers to those. There was a question in the chat earlier, and Kelly talked about it earlier, about having a parent, a guardian, support person in the room during the conversation, the preparation conversation, and this is an important part of preparing witnesses. And again, it's case by case specific, but there are times when you need to say to the child and the support person, maybe it's at the end of the interview, maybe it's at the beginning of the interview or in the middle of the interview. There are some things that I need to speak about with you privately, so I'm just going to ask your mother to wait in the next room and these other people to wait in the next room while we have a private conversation about these things. And obviously these you need to do that if you get the sense that that the child is being coached by the parent, or the child is somehow being unduly influenced by a parent, and you want to double check with the child that maybe there is something that they're withholding, or ask those questions. And so sometimes you need to do that, and other times you don't. I see that there's a question about whether these kinds of tips apply for cognitively challenged or disabled people, and they really do. People with FASD or other brain injuries. And the materials in the LINCS booklet, which I believe is available through the Victim Services Office and the LINCS program on Jarvis Street, have more information about that. But yes, these do apply to cognitively challenged individuals as well. The last part of the meeting, and even in the middle, you can repeat this, is building confidence and self-respect for the witness. So in the criminal context, I will sometimes have, for more mature witnesses, I will have a conversation with the witness about why we're going to court, because the person has not admitted it, whatever the complaint is, and that we are required to prove it. That's the person's right, and we're required to prove it. So you have to come there because because to have somebody held responsible or accountable, and for that person to learn from this process, we need to prove the case. I talked to them about the burden of proof and and proof beyond a reasonable doubt, and what a high burden of proof that is, and the possibility that there will be an acquittal, but that no matter what, I believe you and all of these people that are here on your team, your mom, the victim services worker, the Crown Witness Coordinator, the doctors, the nurses, we're all here on your team. We believe in you. We believe in what you're doing. And we think that what you're doing is heroic because there are so many other young women who won't go through the process or are too reluctant to participate. And what you're doing is protecting yourself, but you're also protecting all of these other people, regardless of the outcome of this case. You're showing this person that you're willing to, stand up for yourself, and that's going to help. And so, I mean, criminal prosecutions are difficult to prove, and there are acquittals. But you want to kind of pre-inform the child that regardless of the outcome, that the child is believed and respected and honored for doing what they're doing. And I think that can be affirming to a child witness. Adolescents witnesses are a category of their own, as I think we all know. They come to meetings or to the court process with often feelings of, or they present with feelings of indifference, defensiveness, open hostility. And you need to remember that those emotions that they're displaying are often used to hide feelings of vulnerability and pain and, the harm that they have experienced, and you can't rise to that or respond to that in any way other than being compassionate and empathetic. Otherwise, the meeting isn't going to go anywhere. And you need to remember as well that adolescent witnesses are going to be particularly sensitive and distressed about speaking about sexual matters, maybe a female witness to a male lawyer, or maybe, to strangers, that kind of thing. And you need to be sensitive to that and maybe have some conversation around that, that these are things that you deal with on a regular basis. Often adolescent witnesses are also reluctant to admit that they don't understand something. So you need to use techniques to, ask the child or the adolescent witness to kind of explain back to you a concept that you think that they might just be feigning understanding of. You want to ask adolescent witnesses whether there is anything that they want you to know about themselves that will help the two of you work together. Ask for their opinions. Youth like to give information where they are perceived as being the experts. And so you can use that tendency to create openings for the child to be providing information or filling in information. Put them in the role of the expert. You never want to sound rushed or impatient. You want to listen and not interrupt. And I think this is something that, as lawyers, we are somewhat less accustomed to. We're accustomed to being the ones that are talking, that are providing information, and that's being received by the other person. But in this role, in preparation and in trial advocacy, it's better to be developing good listening skills and skills that create that openness for the witness to open up. You want to consult with the witness particularly adolescent witnesses, and involve them in decision making about how they would like to give their evidence. So you can talk to them about, what day they're going to come to trial, or how you would like to fit them into the presentation of the evidence and why you do it that way. You can talk to them about whether or not they would like to have testimonial aids and some of the pros and cons around testimonial aids, the timing of when they testify, that kind of thing, and give them some sense of control in that. Talk to the witness about coming to court wearing comfortable clothing, something, bringing objects with them that might be comforting to them. You can talk to them about also, where they're going to be in the courtroom, and tell them to bring a book or a video game or something like that, because you need them to know that sometimes you end up sitting around outside the courtroom for long periods of time. And if a child shows up to the courtroom without any distractions whatsoever and has to sit there for longer than, 15 minutes without, the courtroom is not a particularly child-friendly environment. Remember as well that there are these side rooms, and the rooms are typically locked. All you need to do is go to one of the sheriff's officers and say, could you open up one of the witness rooms? And one or two of them are much more suitable for children than the other couple of rooms that are kind of a desk, a phone, and a chair. So don't be assertive about creating spaces within the courtroom or the courthouse that are comfortable to the children. And I think one of the rooms has a TV set and a DVD player in it. I stand to be corrected on that, but you want the child to have lots of distractions, refreshments, and that kind of thing in the courtroom. I've talked already about clarifying why the youth has to testify. You want them to understand that the judge doesn't receive all of the papers that the lawyers have, and that the trial, we're not allowed generally to just give the judge a copy of the witness statement. Like, a lot of witnesses think that the judge can just read the papers and make a decision. And so you need to clear up that confusion and let them know that the judge who's hearing the case is hearing all of that information for the first time, and that it needs to usually come from the mouth of a witness sitting in the chair. And I've already spoken about, explaining to the youth that they have to do that because the accused person is so far denying that the event happened. So, if the child is feeling uncomfortable, you can ask them during their examination in chief how they're feeling about being in court, and giving a witness an opportunity to say, I don't want to be here. I really feel uncomfortable about, testifying against my dad or my mother's boyfriend. And then I would follow up with a question like, so you're here because you were served with a subpoena and you were kind of compelled to be here? And they're like, yeah, that's right. And that allows them, I think, to relax a little bit on the witness stand, because they've been able to communicate to someone who they have a relationship with, that they're kind of there against their will, or they're sort of protecting themselves that way by saying those things. So I say give the witness the opportunity to explain their reluctance to the judge and to court, and it's powerful evidence as well. With reluctant witnesses, and particularly adolescent witnesses who come to meetings and they don't want to go forward, and they say that they don't remember what happened, sometimes showing those witnesses photographs of injuries, if those are available, can be a very, the steadfast witness who comes in and just, is trying to find that off-ramp out of the court system. Once they look at photographs, if there are photographs of injuries or bruising or, wounds or whatever, I'm not talking about intimate photographs, but, you show those, and those can be a powerful motivator or reminder to the witness, and bring them back to that moment when those things were happening, and then all of a sudden the information starts to flow again from the witness. I've talked about acknowledging at the end of the meeting sort of the witness's distress and ending those meetings with optimism. And I think that that's very, very important. But, you know, practical optimism as well, because you don't want to create expectations for the witness that are later going to be disappointed and then adding to the traumatic experience that, you know, I mean, the initial experience, and then they're kind of re-victimized by the court process. So I think you do need to be, you know, honest about the outcomes that can happen, and never, ever handicap your case by saying things like, we have a 50% chance, or we have an 80% chance, or, you know, that's, from my perspective, bad advocacy. And I think there's some Law Society discipline reports that say that that's not you know, that's not conduct that is becoming of a barrister and solicitor to try and provide, you know, numerical estimates of outcomes. And lastly, in terms of preparation, you can also offer, and many witnesses are interested in this, touring the court facility. Here in the prosecution offices, we have Crown witness coordinators who can take the witnesses, meet them at the courthouse, and show them the courtroom. If you're in a civil firm and you want to do that, you can arrange to do that through the sheriff's office or the court clerk's office. And I would be very surprised if you encountered any difficulties in scheduling that kind of meeting. I mean, it depends on the availability of an open courtroom, but it's a routine part of the criminal trial preparation process for witnesses. Or alternatively, and these, there are visual aids that are available that you can have in your office. And I think these may be available through Victim Services, where it's a little paper page of what a courtroom looks like, and they're little cutout paper figures representing all of the actors in the litigation process, and you can, you know, play kind of house with those with younger witnesses to say, here's, you know, there'll be these people sitting here and these people moving around there, and this is what's going to happen. And you also want to talk to your witness about you know, that they may be asked to promise to tell the truth, but typically the police have gone through that already, and you have a pretty clear understanding of what the child's capacity is in relation to understanding the importance of being honest. So those are the remarks on preparation. I don't know, are there any questions that I've overlooked on that?
Noel, I think Kelly had a little comment that could be useful for the participants about the role that Sue Bogle has now.
Okay, go ahead.
Well, I mean, Sue's actually on this CPD, so she could probably explain it better than I could. But as I understand it, she is now working with Victim Services as independent counsel for victims of sexualized assaults. So that obviously could include children. So that's another good, you were talking about building a team as part of your trial preparation, and that Sue might be another good resource, assuming she's been retained on your case.
Right. Okay. I see it's 10:30, and I have spent much more time than perhaps I should have on the preparation stuff. I think there are some important legal principles regarding children's evidence that I would like to cover, and I think that we'll hear more about this in Simon's presentation as well. So, but I want to begin with the observation that the Supreme Court of Canada, since let's say the 1990s, has radically transformed its advice, I guess, or its directives on the approach to children's evidence. And I will point to two specific cases that are that have been monumentally important in terms of the assessment of children's evidence in court. The first is the RBG case, R versus BG, and that was a decision written by Canada's own RBG, Bertha Wilson, on a bench composed of Mrs. Wilson, Claire Leroux Dubé, Justice Gontier, Corey, and Madam Justice McLaughlin. So, you know, 3 powerhouse female Supreme Court judges. And it was a case involving expert testimony about the behavioral characteristics which were experienced by young victims of sexual offenses. The expert talked about bedwetting, nightmares, and anxiety, and the complainant had talked about, and her mother had talked about the complainant experiencing those same characteristics. And there was concern from the defense counsel that this expert evidence amounted to some kind of oath-helping type evidence. And so that was the specific issue of the case. And what Justice Wilson, for the unanimous decision for the court, said that expert evidence was well within the bounds of acceptable and admissible testimony. But what she said that has been quoted again and again in subsequent cases is that while children may not be able to recount the precise details and communicate the when and the where of an event with exactitude, this does not mean that they have misconceived what happened to them and who did it. In recent years, we have adopted a much more benign attitude to children's evidence, lessening the strict standards of oath-taking and corroboration, and I believe that this is a desirable development. The standard of a, quote, reasonable adult, end quote, is not necessarily appropriate in assessing the credibility of young children. That's R versus BG 1990 to SCR 30. That decision was followed in 1992 by the R versus WR decision, 1992 to SCR 122, which was a decision of Justice McLaughlin writing for the court. The accused had been convicted on 3 counts of indecent assault, count of gross indecency, count of sexual assault on 3 young girls, and the appeal raised the question of the approach which should be taken to the evidence of children. The Ontario Court of Appeal had overturned the convictions based on the absence of confirmatory evidence and perceived inaccuracies in these young children's evidence. And Justice McLaughlin was not pleased at all with the Ontario Court of Appeal decision, and she said that the law affecting the evidence of children has undergone 2 major changes in recent years. The first is the removal of the notion that the evidence of children was inherently unreliable and to be treated with caution. The requirement that a child's evidence be corroborated has been removed, and she talks about criminal code amendments, which formerly prohibited the conviction of a person on the uncorroborated evidence of a child testifying unsworn. So she's talking about legislative developments in relation to the Criminal Code and the Canada Evidence Act that have clearly signaled Parliament's intention that children's evidence is to be treated just like the evidence of any other witness. She writes, the assumption formerly applied to all evidence of children, often unjustly, that children's evidence is always less reliable than the evidence of adults. That assumption is in the judicial trash can. And she says, the second change in the attitude of the law toward the evidence of children in recent years is a new appreciation that it may be wrong to apply adult tests for credibility to the evidence of children. She writes, one finds emerging new sensitivity to what she calls the peculiar perspectives of children. Since children may experience the world differently from adults, it's hardly surprising that details important to adults, like time and place, may be missing from their recollection. And then she quotes Justice Wilson in the RBG case, and she talks then about how the presence of inconsistencies in children's evidence on peripheral matters like time and location should be considered in the context of the age of the witness at the time of the events to which the witness is testifying. So, you know, those two cases, I think, really sent a strong signal to lower courts about, you know, not requiring corroboration of children's evidence and treating children's evidence through a special lens. Also, with respect to kind of legal principles on children's evidence, proof of age is obviously something that needs to be established, and in the criminal context, at least, Section 658 permits a witness to testify about the date of his or her own birth, or other proof may be given by a parent or you know, a birth or baptismal certificate or other reliable evidence. So, as well, the common law permits a witness to testify about his or her own age, even though that witness's knowledge is based on hearsay. So you don't need to get tripped up on that. You can ask a witness how old they are, and don't bother trying to attack them or the admissibility of that evidence based on hearsay. Let me just see. Okay, I've got a few more minutes to cover what I think are also very important legal principles under Section 16 of the Canada Evidence Act. And I talked about the pre-existing law concerning the competence and reliability of children's evidence. And as I say, the law in the past has taken a very unfavorable approach to that has been dramatically modified. You know, there was a tremendous inequality between what the law regarded in terms of children's evidence versus how the law regarded adults' evidence. And basically, you know, evidence, a witness needs to be competent to testify. And in a decision called Marquard, 1993 for SCR 223, Justice McLaughlin described what testimonial competence is. And it's simply the capacity to observe and interpret events, the capacity to recall those events, and the capacity to communicate those events. It's not, you know, a witness has capacity if they meet those very limited characteristics. It's not about whether the evidence that the witness relates is credible or reliable, but only that it meets a minimum threshold of being receivable. So, you know, and that's what these legislative amendments in Section 16 have addressed. And in Marquard, Justice McLaughlin says that this threshold for capacity, testimonial competence, is not a high one. It's just a basic ability to perceive, remember, and communicate, and that deficiencies in perception and recollection go to the weight of the evidence. That takes us into the Canada Evidence Act, and the recent, there were amendments in 2005 and 2015 that made the evidence of children presumptively admissible in criminal proceedings. And a person under Section 16.1 of the Canada Evidence Act, a person under 14 years of age is presumed to have the capacity to testify, and they are not required to take an oath or affirmation before giving testimony, but there is an inquiry by the trial judge, and the witness under 14 years of age must promise to tell the truth. It used to be that there was an inquiry mandated by Section 16 of the Canada Evidence Act, and that this was a fruitful area for some defense counsel who wanted to sideline the witness by opposing the competence of that witness to testify, and children were exposed to cross-examination on this competence voir dire, having to answer difficult abstract questions about honesty, telling the truth, lies, etc. And many kids were kind of flummoxed by these, and then their evidence was excluded because the judge wasn't satisfied that the competence threshold had been met. Now we have these amendments to the code that presume capacity and eliminate this voir dire, capacity voir dire, but do require the judge to have a conversation with the child and to get a promise. That conversation doesn't need to be a formal, particularly formal, and any exchange between the judge and the child in which the judge commits to telling the truth will suffice, even if neither the judge or the lawyer uses the word promise. That's a Ontario Court of Appeal decision in FCC 2014 on CA 327. If a party challenges the capacity of a witness to testify, there are two inquiries. And so, defense counsel still can challenge capacity. And the court needs to make a determination whether the witness can understand and respond to questions. That's the statutory threshold. That's for witnesses under 14. That's the competency threshold. For witnesses who are over 14, the question becomes whether the witness understands the nature of an oath or a solemn affirmation, and whether that person is able to communicate the evidence. So it's made it much easier to introduce evidence from children, young and adolescent, and as well from people with cognitive difficulties. I think I'm almost out of time here. These inquiries under Section 16 are made based on the age of the witness at the time of the trial, not at the time of the offense. There are also evidentiary shortcuts with respect to preliminary inquiries and tendering. Instead of calling witnesses, child witnesses, you can adduce their evidence through credible and trustworthy evidence, like transcripts of statements and police officer testimony that a witness met and gave certain information. And the courts in the Yukon have been, respectful of the discovery function of preliminary inquiries, but also willing to limit the cross-examination of child witnesses on their statements that are adduced on paper by the Crown. Adult witnesses don't receive quite as much shielding from the courts from cross-examination of preliminary inquiries. And as well, there's at trial, Section 715.1 that permits the tendering of video recorded statements of child witnesses for the truth of their contents at trial if the child comes to the trial and adopts the contents of the pre-recorded statement, even if they don't remember what happened to them, if they say that they were telling the truth at the time they made the recording. And those records are only admissible if they were made within a reasonable period of time after the event that is reported in them. And there are a number of different cases that discuss that reasonable period of time requirement. And I won't go through all of the cases. If you have questions about this, I can provide you with lots of case law citations, but delays up to 3 years after the event that are reported by children can be found to have been made within a reasonable period of time. It's all kind of circumstance dependent, but it doesn't have to be made within 24 hours of the event that is, the offense that's reported. It can be disclosed long after, depending on the rationale for that delayed disclosure.
I'm sorry, I think
I'm getting the hook here, so I'm not able to talk about testimonial aids, and maybe I'll try and find a way to squeeze that in later on in the process.
Well, what I was going to suggest as well, Noel, is because we also didn't have time for questions, which I think is fine because we didn't have any come in, but can I volunteer you if people do have questions? Can they just email you?
Yeah, they can email me at noel.sinclair@ppsc.gc.ca, or they can call me directly on my office line, 867-667-8102. I'd be happy to answer any and all questions.
Okay, great. Thank you so much. I personally found that very useful, especially your trial prep tips. So thank you again. Before we take our next break, I just wanted to clarify, Sue Bogle wrote in, I think when I was describing what she does, I think I narrowed it a bit much. So she's clarified that in her comment. She says there's free independent legal advice for any victim of sexual violence or intimate partner violence, any age. Charges don't have to have been laid. The only prerequisite is that the violence happened in the Yukon or the victim currently lives in the Yukon, and that service can be accessed through victim services. So thanks, Sue, for clarifying that. That's really valuable. It's really good to know. Okay, so we're still just going to take a 15-minute break. So we'll come back at 11 o'clock for Simon's talk. Thanks. Okay, welcome back, everyone. So I see, hopefully all the participants can see that Noel just provided some information about the Project Links resource guide, where to get it. So thanks for that, Noel. And if the participants can't see that, if someone could just let me know and I can share it some other way. So the last session we have scheduled today is with Simon Reneuve. He received his BA from the University of Toronto in 1971. He received his LLB degree with distinction from the University of Alberta in 1989. Since 1990, he has been a member of the Alberta Bar. He's a member of the Criminal Trial Lawyers Association, and he acts as trial and appellant defense counsel in criminal cases. He's appeared at all levels of court in Alberta, the Yukon Territorial Court, and in the Supreme Court of Canada. In addition to his criminal law practice, he represents clients in professional conduct and administrative law matters before the courts and numerous federal and provincial administrative tribunals. And in 2000, he was appointed Queen's Counsel. So we're lucky to have him here with us today. We kind of gave him a grab bag of topics, but generally what it boiled down to was how to cross-examine a child witness without harming the witness or your case. And so I'm hoping he'll touch on that topic as well as any others he wishes to speak about. So welcome, Simon.
Thank you very much, Lauren. And I'm fully cognizant of my privilege in being on this exceptionally qualified panel. And, I have to say, I've had the privilege of litigating against Noel Sinclair in the Yukon Territorial Court. And if I had known that he was a retired fishing guide, everything would have clicked into place. His skillful use of lures and bait and nets to win the case was something that I could not have predicted without knowing that training that he had in his background. So you learn a lot in these seminars, and I think that was very valuable.
We don't win cases, Simon, you know that. The Crown never wins or loses. I often tell myself that,
you just
especially when I lose.
landing the big one. I know. Yeah. Let me say at the outset that I'm here to bring a defense perspective, and I do. But I think we all recognize that crimes against children, or crimes where children are witnesses, which are not necessarily the same thing, are as worthy of rigorous prosecution as any other crimes, perhaps more so. But we also have to keep in mind the particular difficulties associated with a prosecution that's based on the evidence of a child witness, usually as very important evidence, particularly in child sexual assault cases, because of the circumstances in which the alleged sexual assault took place. And so it's important for us to appreciate the cognitive development issues that have been talked about, and particularly the reality that children do not experience reality in the same fashion as adults, and their experience of reality changes at different ages, and their ability to communicate what happened to them or what they remember happening to them changes at different ages. And the most significant challenge that defense lawyers have in 2021 is the evolution of the law that Noel touched on, which is that judges are being instructed by appellate courts and by the Supreme Court of Canada to take a deferential, indeed lenient, view of what would otherwise be frailties in the evidence of a witness. So we have an adult witness of average intelligence and education who has a variety of unexplained contradictions in their evidence, gaps in their story. It would be expected and probably perfectly natural to have a judge express serious concerns about that witness's credibility. And the appellate courts and the Supreme Court of Canada have told lower court judges that these deficiencies are to be expected in the evidence of child witnesses. They're to be expected from truthful child witnesses, and therefore they're not a basis for disregarding or limiting the weight that's applied to that evidence. And the case law is really quite what's the word I'm looking for? It's unvaried in this regard, and if anything, it's simply got more assertive in this directive over the years, which is based on the assertion, I think it's legally correct, that a finding of credibility is a finding of fact. So that a trial judge's determination that a complainant is credible is a finding of fact which is entitled to a great deal of deference by appeal courts and is virtually non-reviewable. Noel and I were chatting yesterday, and I was quoting from memory a newspaper article that I had read in December that talked about 10 consecutive Supreme Court of Canada decisions where the Supreme Court had overruled provincial courts of appeal that had in turn set aside convictions and substituted acquittals or ordered new trials in sexual assault cases, many of them child sexual assault cases, 10 in a row where the verdicts of guilty were reinstated by the Supreme Court of Canada. And I think since the new year, not much has changed other than that there have been a few more that we could add to that list. So we're probably up to 13 or 14 consecutive cases for the Supreme Court of Canada restoring trial level convictions in sexual assault cases. There's one fundamental lesson that defense lawyers have to take from that, which is this: if you're going to win a sexual assault or a child sexual assault case, you have to win it at trial. You're not going to win it on appeal if you lose at trial, because you run the risk that even if you're successful in the territorial or provincial court of appeal, of having that decision further appealed. And let's face it, the provincial and territorial courts of appeal are only going to be reversing trial level convictions for so long until they get the message, which the Supreme Court of Canada is unequivocally sending to them, which is not to reverse those convictions on the basis of unsatisfactory evidentiary foundations. The Supreme Court of Canada has firmly stated in many, many cases, not necessarily all that recently, including cases going back to the ones that Noel referred to in his comments, like the RW case from 1992, that things like the demeanor of a witness, the ability of a witness to recognize or remember events, the inconsistencies of a witness. There's no value in going to an appeal court listing those problems with a witness's evidence, because the answer is those are findings of fact, and those are findings of fact which are essentially non-appealable. We've always had in Canada a basis for criminal appeals that could be described as an unreasonable verdict. And in 2014, the Supreme Court of Canada made clear that there are two separate standards for unreasonable verdict for trial judges and for juries, because the appellate court is allowed to look at the trial judge's reasons when it's a judge alone case. And of course, there are no reasons when we're looking at the findings of fact that a jury has come to. There may be, of course, issues that could be subject to appellate review from the judge's charge to the jury. But in terms of assessment of credibility of the witnesses, there's essentially today no such thing as an unreasonable verdict that could be corrected by an appellate court. For me, in my practice, what that means is that I am essentially taking everything that is litigated to a jury trial. And I can reinforce that by another story from the Golden Mail from more recently. From back in October, but I believe that this legislation has now passed, and that's on the approval by Parliament of a bill to make judges' sexual assault training mandatory. And quoting from the article, Bill C3 would require new federally appointed judges to agree to take training, including learning about rape myths and stereotypes and how to make sure biases about race, gender, and other social factors do not influence their decisions. It would also require judges to put their reasons on the record when ruling on sexual assault cases. Well, of course, training is a good thing. Judicial training is probably more of a good thing than other kinds of training. And it would be delightful if Parliament were to also legislate that there should be mandatory judicial training on the over-incarceration of Indigenous people in Canada, or mandatory judicial training on mental health and the law, or mandatory judicial training on the impact of the war on drugs on the criminal law. So far, Parliament has not expressed its opinions on those aspects of the deficits in judicial training, and I'm not expecting it to do so in the foreseeable future. So again, what that tells me in my practice is that if it's necessary, in those cases where it's necessary to litigate an allegation of child sexual assault, that it needs to be done in front of a jury, and that essentially the findings of the jury are going to be sacrosanct. As I said at the outset, if you're going to win, you have to win at trial, because you cannot count on winning at appeal. So talking about preparation for a trial where there are going to be child witnesses, I really don't take issue with anything that my two colleagues have said on this panel. It's so important to recognize developmental psychology with respect to the capacity of children. I guess the one other factor that since Jean Piaget was writing about developmental psychology in the 1930s to the 1950s, the one additional development or revision to that is the recognition of cultural influences on child development, that not all children develop in the same way, and a sensitivity to the cultural background of the child witness is also important in understanding their developmental psychology. But that's the starting point, both for examination in chief and cross-examination, is to understand the capacity and limitations of the witness. And of course, if the defense is going to be suggesting that what the child has testified to is untrue, then there has to be an air of reality to accompany that, because even a jury without the specialized training that the judiciary may now be receiving is not going to simply slough off the evidence of a child because of at least minor inconsistencies in timing. As my colleagues have acknowledged, Kelly mentioned it particularly, one of the problems in sexual assault cases dealing with child witnesses is that there's a risk of children being recruited as child soldiers in the war between their parents. And I'm not sure that I would agree that it's always that easy to detect. That yes, indeed, that can be if the child has been coached and manipulated by one parent to give evidence against another or a member of the other parent's family. There will be inconsistencies that develop, but were being asked by the appellate courts to overlook inconsistencies in the witnesses' testimony. So that it remains a risk. It remains a risk to the criminal justice process because despite the rulings and the training that have and the directives that have come from the appellate courts, the fundamental principle still applies that there can only be a conviction if it's based on something very close to certainty, and that doubt must be applied to the benefit of the accused. One of the things that I'm very cognizant of when I'm cross-examining child witnesses is the rule in Brown and Dunn. It's an important legal rule, and it applies, of course, in every case, in both civil and criminal cases where you are cross-examining a witness. And essentially, to recap, it's a rule of fairness that if you're going to contradict a witness, even in your final argument, or if you are anticipating calling evidence that would contradict a witness, you have to put that to the witness. So that rule applies with children just as it does with adults. It's a little more complicated with children because we're dealing with this developmental psychology factor. Of course, we are with adults too of varying capacities, where the intellectual nature of the rule in Brown and Dunn might not be immediately apparent or understandable. And so posing a contradictory scenario to the witness may be perceived as an attack or a lie or upsetting in some fashion. So it's got to be done delicately. It's got to be done fairly to comply with the rule in Brown and Dunn, which means it's got to be done in a full, comprehensive fashion. So, for example, if the defense is that it wasn't Uncle George, it was Uncle Fred, that's got to be very clearly put before the witness and put on the record. And if there are allegations of coaching or manipulation, those are going to have to be put to the witness. They cannot come back properly. I mean, I appreciate that there's errors and omissions in every litigation process. That's why Noel and I love the litigation process, because you're living in the moment and it's a human process. But it's one of those areas of cross-examination that is quite heavily scrutinized by the trial judge. And so it's much better to get it right the first time than to be corrected on it in the course of the trial. And that is to put alternate versions of the facts fairly to the witness in language that the child can understand, and in, as I say, in a fashion where the child can, at least to some extent, grasp the intellectual process that is going on when you are suggesting an alternative version of reality or an alternative set of facts to the witness. I'm going to talk a little bit about some of the statutory provisions that Noel didn't have a chance to get to. And before I do, I'll just have some fun here and take issue with or ask some questions about a couple of the things that my colleagues on the panel have suggested. I don't think it's good practice for the police when they're conducting a recorded interview, and it wasn't perhaps really explained in Kelly's comments, but I inferred from that in many cases, Kelly, the interviews were being done for the purpose of 715.1 of the Criminal Code that is to be presented in court and with a view to being adopted by the witness. And so I would not think it's a good idea to have anybody else participating in it. We have, different agencies. We have support workers. We have victim services units. I don't know, your beagle, Kelly, reminded me of our support dog that we have at the law courts in Edmonton, and I think in a few other courthouses in Edmonton, in Alberta. And there's a dear old elderly yellow lab who pads around the courthouse, and it's quite sweet to see her in court with these child witnesses, and they can have this lab sitting on their lap while they're testifying. And I was standing in line back in the days when we were allowed to stand in line at the courthouse at some criminal counter or other, and the old lab went padding by, and lawyer behind me said, "That poor lab, how many lies has she heard over the years?" but she's a dear thing, and she does not react. She doesn't flinch no matter what is going on in the courtroom. And I'm sure she does give some encouragement to the child witnesses. All of those things are good. But I would think that it's probably not good practice for the recording of a 715.1 statement to have anybody else in the room besides the police officer and the child himself or herself. I have seen it done at the child's home. It was a reluctant witness, and the police showed up when she was out and waited for her to come home. And I thought it was a poorly done interview in that case, and perhaps because of that, that it's or at least that was one of the contributing factors to it. There's a legal issue with respect to these 715.1 statements that defense counsel should be alert to. Of course, it's admissible as evidence to supplement the viva voce evidence of the witness, but it doesn't replace their witness at trial. And in jury trials, there's sometimes an automatic tendency, and I have kicked myself for not catching this in at least one case where I was involved as defense counsel. An automatic tendency for the court to send the thumb drive with the recorded 715.1 statement that's been adopted. So it's been properly entered as an exhibit, and it's sent into the jury room with the other exhibits. I'm not sure what the trial practice is in Yukon, whether that's typical to send all the exhibits into the jury room with the jurors. And this kind of escaped my my notice at the time. And the concern is that it would privilege the recorded statement made with the police officer over the examination in chief and cross-examination of the witness in court. It's not to be privileged. It's simply something to be weighed by the trier of fact as part of the evidence overall of the child witness. And I believe that it was probably a mistake on my part to allow that to happen. And I would not do that in the future, that I would object. The case law on that is not very well defined. It says that it's within the discretion of the trial judge to determine whether the recorded statement should go into the jury room with the jury. I think I would put up a fight and say that if they want to hear it, they can come back into the courtroom and have it played back to them. and also at the same time play back the audio of the examination in chief and cross-examination. So again, they have the full picture of the evidence of the child. I did have one concern in Noel's presentations about the suggestion that the Crown should say to the witness, "We're here for you, we're your team, we believe you." I have never been a Crown prosecutor, so I have never had to face the tension that Crown prosecutors face between their ministerial obligations and their natural inclination to want to help people who are perceived as victims of crime. But I would suggest that's probably not wise. For one thing, it can paint a person into a corner. If they haven't been under oath before, they haven't been in court before, they haven't been subject to a solemn promise to tell the truth before, and if they have not been telling the truth, does it help to say we believe you? Or does it merely have the negative effect of making it harder for them to change their story when they get into court? So that gave me a bit of a turn, but that's of course an individual decision that would have to be made in each case. I'm going to touch on, sorry, the one case that I was referring to, that Supreme Court of Canada case that and I said 2014, it's from 2013, is Regina and WH. This is the one about the two standards of unreasonable verdict, one where there's a trial by judge alone and one where there's a jury trial. That's R versus WH 2013 to SCR 180. And there is, as I mentioned, a quotation from the earlier decision of R versus RW from 1992. So that's a good case that really solidifies, I think, more than anything else, the reality that we're all dealing with today is that the Supreme Court and the appellate courts have been directed, at least, not to substitute themselves for a jury, not to act, as the Supreme Court of Canada said in WH, not to act as a 13th juror, or simply give effect to a vague unease or lurking doubt in its own review of the written record. Again, in an era where judges are being heavily criticized for acquittals and subject to mandatory training, a mandatory training regime, it seems to me that it's necessary to at least consider very seriously jury trial in every case which is going to be contested. Now, I want to just touch on some of the criminal code provisions that are applicable to the evidence of children. These follow section 486 in the criminal code. 486.1 is an entitlement to a support person. That is a support person to sit with a child in court. As I said, with our support dog in Edmonton, there's usually a handler, a very nice person from Victim Services who simply just sits in the same area as the witness and the dog. And we have, and again, I apologize for my lack of Yukon knowledge, but we have several specially constructed courtrooms where there is a screen so that the child witness cannot see the accused cannot see the child witness. the jury can see the witness and the dog, and the accused can see the witness on a video link. And 486.1 sub 3 sets out the factors that the court should consider in deciding whether there's a support person to be allowed. I've never heard of anybody contesting that, but I suppose it may have happened. It's not something that I would contest. 486.2 deals with testimony outside the courtroom. Again, normally that's reserved for children, but there are some specific circumstances where it can apply to adults. So that is to testify from a separate location. And again, subsection 3 of 486.2 deals with the factors that the court should consider in making that determination. One of the reforms in the criminal code is that an accused person representing themselves, that is what we would call a self-rep or an unrepresented accused, is not allowed to cross-examine a witness under the age of 18. And again, there's factors to be considered, and what that would normally lead to in Alberta is the appointment of an amicus curiae to conduct the cross-examination of the child witness on behalf of the accused, even in cases where the accused is self-represented. There are factors, there are some sections that deal with non-disclosure of the witness's identity, that's 486.31, and publication orders, 486.4, 486.5. And as we've discussed earlier, 715.1, evidence of a victim or a witness under the age of 18. Now, while I've been yammering on here, I see that there's been a number of Q&As. So maybe should I just look at that, Lauren, to see if there's anything that applied to me, or are they all?
Yes, I think there is a question. There's 2 questions and 1 clarification. So
okay, could you do the honors?
Sure. So the first question we got through the chat was, and I think you might have answered this already, but given the current appellate atmosphere, is there an argument it may be advantageous to elect jury more often?
I think I've answered that. So it's called taking your chances. I mean, there's of course numerous other issues on jury trials. I've been litigating, and it just was declined leave or refused leave from the Supreme Court of Canada on a provision of the Alberta Jury Act, which we felt led to an underrepresentation of Indigenous persons on jury panels. It's because of we have a blanket prohibition on anybody with a criminal conviction, an unpardoned criminal conviction, from sitting on a jury. And we led expert evidence that first of all, of course, as we all know, Indigenous persons are more likely to have a criminal record than non-Indigenous persons in Canada. And secondly, Indigenous persons with a criminal record are less likely to seek a pardon than non-Indigenous persons with a criminal record. So it's kind of a double whammy. And when Parliament removed the peremptory challenges on jury selection, the concern that was expressed was that council were using peremptory challenges to remove Indigenous people from, or prevent Indigenous people from being on the jury. And myself and a few other people have said, that's not our problem in Alberta. Our problem in Alberta is not getting Indigenous people on a jury panel. So that's one of the problems with jury trials that we all have to grapple with, that if the accused person is of Indigenous descent, it's very hard to get an Indigenous member, one or even a few, on a trial jury in Alberta. So there's other issues about juries, but yes, I generally take everything to a jury that is going to be contested. That doesn't mean that I'm in jury trials all the time. I do a lot of plea negotiations as well, but if it's going to be contested, I believe in taking it to a jury. When I started practicing law in the 90s, the conventional wisdom was, on a sexual assault case, you didn't want the man on the Clapham omnibus, which was the old-fashioned way of describing the reasonable person, to be deciding the fate of your client. And I've seen in the course of my 30 years as a lawyer that the pendulum has swung completely the other way, and most defense counsel would not want a judge who has been criticized for acquittals and has been subjected to mandatory judicial instruction to be deciding a case when they could, if they wanted, have a jury to decide it.
Controversial viewpoint, perhaps, but I understand the strategy behind it. So, another question we had.
You're not a prosecutor, are you, Lauren? That's not.
This panel is weighted against you. Yes.
I will observe that Simon has the perhaps professional misfortune to be practicing as a defense lawyer in what is arguably Canada's most law and order jurisdiction in Alberta, and that it might be that some of his concerns are less poignant in the Yukon and BC environment that we operate in, where justice has its own flavor.
I'm sure that's true. I saw another question come in there, Lauren.
Yes, so if you have time, which I think we do, could you expand on your views concerning the role of an amicus appointed to cross-examine on behalf of a self-rep?
Right. Well, I'm probably not ideally suited to explain that role, since I've never been asked to undertake that function. But my understanding is that they would be appointed by the court to conduct a proper, full cross-examination of the witness, and essentially to comply with the criminal code provision that the witness not be subjected to being cross-examined by his or her alleged abuser, which makes, of course, sense because of the potential intimidation factor. And but that they should not pull their punches because they're amicus curiae. They're only going to be of assistance to the court if they conduct a probing and complete cross-examination. I'm not sure. Noel, have you ever had any involvement with one of those processes?
Yeah, in the Yukon, they're not appointed as amicus. I think that's not their title, because the role of amicus was, about 8-10 years ago, really constrained by a decision from the Supreme Court of Canada, the name of which I can't recall. They are appointed as counsel for that person for the purpose of cross-examining the complainant, and I think Mr. McWhinney's question might be getting to the issue of the scope of that person's representation. I mean, does that appointed lawyer simply show up on the day that the complainant testifies and conduct a cross-examination of the complainant, having met with the client and reviewed all the disclosure? or are there professional ethical obligations on that appointed lawyer to be present and provide information or advice to the self-represented accused person with respect to the evidence of other witnesses, or how that all fits together with the cross-examination of the complainant. We have seen cases here where sometimes the lawyer is simply in and out for that very strictly confined execution of that role, and in other cases the lawyer takes a more broadly based approach to their involvement as court-appointed cross-examiner.
Thanks, Noel. One question that came in, I think should probably be answered by both of you, perhaps Simon and Noel, because it might apply to Crowns as well. Any advice about circumstances where a child witness or other developmentally challenged witness who recants their prior allegations, particularly in circumstances where it appears they are doing so under pressure from an adult or parent? I mean, for defense counsel, I would think that wouldn't pose much problem for you because that's only strengthening your hand.
From the Crown prosecution perspective, I mean, clearly that is highly relevant information that must be disclosed to defense counsel. It doesn't necessarily put an end to the prosecution because if the Crown counsel forms the opinion that recantation is somehow unreliable, then we will continue to press on with the prosecution and see how the witness testifies at the trial when the gravity of the situation is more fully apparent to that witness sitting in the witness chair in the courtroom, having promised to tell the truth and so forth. I mean, there are lots of cases where we get recantations, and many of those cases are we receive recantations that we're not really confident in the reliability or truthfulness of, and we make decisions on a case-by-case basis. But because the way that the decision to prosecute criteria are written in the Public Prosecution Service desk book, you know, it's not the Crown's job to sit as judge or jury and decide, you know, proof beyond a reasonable doubt. If there is a reasonable foundation for the case to go forward, then it should, and we need to be, I think, practically alive to all of the strange dynamics that can occur, particularly in family situations when someone is subpoenaed to testify. But the disclosure is going to be made to defense counsel without question.
Yeah, of course, in a case, and I think this was kind of implicit in the question, in a case where there's a suggestion that there's been an induced recantation because of pressure from the accused or somebody, you know, a relative of the accused or somebody acting on their behalf, that's of course extremely damaging to the accused and sometimes can result in a mistrial. Certainly to the extent that there's any evidence of that that has been heard by the court. So those aren't the kind of recantations we look for, and as defense counsel, and they're not valuable. They're harmful for the most part. Recantations sometimes happen. And of course, they are valuable. Again, going back to the notion of a jury, it's not that the juries are uneducated about child development or other issues relating to being a witness. I'm always impressed by the focus that jurors bring to their job and you know, as much as you can tell, we're not allowed to question them in Canada, and we don't really know how they come to their decisions. But as much as you can read from body language and things like that, what we know is that juries don't like liars. They don't like lies. They don't like people manipulating witnesses. I know many years ago, I had a case where the complainants against my client had tried to, or the evidence was, I'll put it that way, the evidence was that the complainants had tried to manipulate their younger siblings into testifying against their father. And the younger siblings gave evidence about these efforts at manipulation that were made by their older siblings. And it was tragic. It was the division in the family was tragic, but I am certain that the jury believed the younger kids when they talked about their older siblings trying to influence them and to manipulate them to testify against the father. And it was a critical piece of evidence in securing the acquittal of the accused. And the other thing about juries for lawyers, the defense lawyers that are listening, is that they take the WD instruction very seriously. The courts are required to give a very clear instruction about where the accused chooses to give evidence, about assessing the credibility of the accused, and linking the credibility of the accused to the issue of reasonable doubt. And my experience and my observation, as much as you can mind read looking at the people across the room, is that jurors take that WD instruction very, very seriously.
There were a couple of points that I wanted to make. First of all, I accept Simon's comments about, you know, telling the witness that you believe them, and the concerns that he expressed about that. And I think those points are well taken. And I will say that it's not in absolutely every case that I would say that. But I will say as well, and I suggested in my comments, that I wouldn't necessarily spend time during a meeting with a witness reviewing their statement with them. I want to make it clear that they always do get a copy of the statement, or if they're too young to read or whatever, they will review, you know, they will look at it before the trial. It's not that they're just sort of, I expect them to come in cold, but I'm not going to spend time during the meeting discussing that with them. And then either, you know, after they've reviewed the statement, I will always ask if there is anything different, you know, check in with the witness and make sure that they are adhering to the evidence and saying it's okay if there are, you know, if you've expressed things imperfectly when you first gave your statement, and find out about that and explore that. So, but I think the point is well made by Simon. The other, there's one other testimonial aid that I did want to speak to, and that is under Section 132 of the Youth Criminal Justice Act, and under Section 486, subsection 1 of the Criminal Code. Courts are allowed to exclude the public from the courtroom. And I have found it frustrating in some cases where this option has been presented to a witness by a victim services worker as something that they might reasonably expect to have happen to make it easier for them to give testimony, you know, in a circuit community or whatever. And it has in the past been presented by victim services workers as the go-to kind of testimonial aid that they think that the victim should have or benefit from. My own perspective is that it really is the rarest of cases where the entire public should be excluded from the courtroom for the benefit of a witness giving testimony. The orders can be made where it's in the interest of public morals the maintenance of order or the proper administration of justice. And there is a recent case law from the Northwest Territories Supreme Court, Justice Charbonneau, in a decision called MK 2017 NWTSC 27, where the court looked at these provisions and talked about how the open court principle is fundamental to our administration of justice, and talked about what's known as the Mentag-Dagenet test, which applies to publication bans for criminal proceedings, and it also applies to the assessment of whether it's in the interest of public morals and the maintenance of order, et cetera, for these excluding the public from the courtroom proceedings. And Justice Charbonneau said that that there is this shift in perceptions of the administration of justice that allows judges to give more consideration to witnesses' interests and the desirability of witnesses providing a full and candid account. But there are also some very extremely important constitutional principles around open courts. And so applications to exclude the public from the courtroom are treated with the utmost gravity and require a very comprehensive evidentiary foundation before the court should entertain that kind of application. So, I mean, I don't know exactly who our audience is in this presentation, but I would say that, you know, there is this cultural and jurisprudential shift towards providing greater supports for victims. And the code seems to suggest that the public can be excluded, but I think it's important to say that, at least from my own perspective, this is a very last resort, and the court needs to consider other less significant interventions to protect child witnesses, such as CCTV or I don't know, you know, there are other support people, et cetera, and it'll be interesting to see how the law evolves in this area. Thank you.
Okay, thanks, Noel. I'm going to jump in because we have, I think, one clarification and two questions to cover before we end, and we only have 5 minutes left. So the point of clarification from a former criminal law policy analyst is that the bill on sexual assault training did not actually receive the approval of Parliament. It died when an election was called, but now it has passed, it's come back, it's passed the House of Commons, and it's currently at second reading in the Senate. So it's not quite the law, but it looks like it might get there. And then a question specific to or directed at Simon. Do you think there is utility in seeking to obtain copies of the training resources that will be part of the mandatory judicial training? Interesting question.
A really good question, and there have been a number of applications that have been made to the National Judicial Council or its training branch. I can't remember its official title right now. They have so far refused. That's my most up-to-date information, is that they have so far refused to provide their training materials, and so the issue, I think, is going to be elevated through the courts. And, you know, there's something kind of dicey about questioning the judge at the outset of the trial about what he or she has been exposed to in the way of educational materials. I think one runs the risk of being told that it's none of your business, which perhaps these days it is our business. But I suspect that the request directly to the training facility, that is the Canadian Judicial Council's educational arm, will probably end up going up through the system and may eventually get to the Supreme Court of Canada.
Interesting, something to watch. And then a question for Noel. Do you do anything different if preparing a child witness to testify before a jury, I guess, versus a judge alone trial?
Well, I will admit that I haven't tried a case involving a child witness recently in front of a jury. And I suppose my answer would be theoretically not really, other than to explain to the child that the person, you know, that they need to be speaking to the jury and projecting their voice and being loud and letting them know that, you know, that there will be people there. It does create some complexities around challenges for cause and relationships, you know, jury vetting, which the child or the child's parents, depending on the age of the child, would have to become involved in to ensure that we are aware and defense counsel is aware of pre-existing relationships between prospective jurors and the Crown witnesses that might impede that juror's ability to decide the case impartially. But apart from those more kind of remote concerns, I don't think I would have anything sort of extra to offer to the child.
Okay. I think we're quite close to 12 o'clock now, and I don't see any more questions. So we might leave it there, I guess. I think we've lost Kelly, but a big thank you to our panelists. That was, at least I found it very informative. So I'm hoping our participants feel the same way. And you can expect some kind of small thank you gift in the mail or coming your way as a token of appreciation from the Law Society for participating. So thank you very much.
Thank you. It was a pleasure.
Thank you.
Nice
Lauren.
to see you, Simon.
Yes, good to see you both. Bye-bye.
Okay. And I'm going to put it on mute and leave it for Lynn to figure out how to end the call. Have a good day, everyone.